How much is the deposit in a probate real estate sale in California? We'll get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Mohr, Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary. I'm also a registered and bonded California legal document assistant specializing in probate work, as well as I am a licensed California real estate broker.
Now, please like this video, subscribe right now. Don't overpay. Want a fast, easy, and no-cost probate service? We have a team in every county in California where we help people save thousands of dollars and eliminate headaches through our one-of-a-kind cost savings, probate administration service, and real estate listing combo. If it's in California and real estate needs to be sold, you may qualify. So reach out, even if you started probate with someone else or on your own. Our info is in the About section on this channel. We love your calls, texts, emails, and comments. Now let's get into it. So it's how much is the deposit in a probate real estate sale in California? And what we're talking about here is the earnest money deposit as part of a probate real estate sale. So Bill, what is essentially the definition of an earnest money deposit? Now we have some notes here because the subject, I don't want to miss any of the details here. So we'll be checking some of those.
Absolutely. Well, essentially what the earnest money deposit is, it's a deposit from a buyer to help ensure that the buyer abides by and does everything in the contract that he or she is supposed to do. It's usually a small percentage of the contract price, and it kind of acts as a placeholder. Usually it's submitted, I believe typical contracts, it's within 3 days of the acceptance of the contract. So it is kind of important that the buyer gets that into the title or escrow company as soon as possible.
As a realtor, I'm always looking forward to when they put that deposit in, because that's when it really feels real that the buyer's serious.
Absolutely. And then maybe you want to go over how the deposit is protected by certain contingencies?
Yeah, it often is. Now, usually when a buyer puts in an offer, they will have what's called contingencies, and something that's going to essentially protect their deposit, that they can cancel the sale and get their deposit back if they have these contingencies intact. Sometimes you get an offer with no contingencies. That tends to be in either a very, very hot market or maybe an investor flipper type who's going to pay cash, who's going to not care so much about inspections. Maybe they already had a thorough look at the property. But in most cases, there's going to be some sort of contingencies. A buyer's deposit, like I said, is protected by contingencies. It could be an inspection contingency based on the condition of the house. It could even be based on whether or not they can procure insurance for the home. Appraisal and loan contingencies. Those are the most common. And if a buyer removes their contingencies and then cancels the sale, then the seller keeps the deposit. Now that's actually uncommon, but it can happen. Now, as far as it goes in probate, there's some common misconceptions about probate sales and how much that deposit is supposed to be. Get into that a little bit.
Sure, and boy, are you not kidding about misconceptions on that. I would say the biggest misconception is that a lot of people who are unfamiliar with probate, especially realtors and agents, they think that you've got to come up with 10% of the sales price of the home as the earnest money deposit. And that's really not true. I would say in 95% of all probate sales, that does not apply at all. The deposit will be what it would be in a normal type of a sale. It's been suggested in certain situations that you do have to have the 10%. And again, it's a suggestion. It's not a hard and fast rule. And to be honest with you, I'm not entirely sure where that actually, some people believe that's a hard rule. It might have come from years and years and years ago in probate. The rule might have been that, and at some point it may have been changed or dropped. But I don't believe there's a hard and fast rule on that. Especially in what are called full authority sales. When you have limited authority, which we've talked about in other videos and things, there are times in a court confirmation sale where that 10% rule may come into play. But again, it's not a hard and fast rule, not at all. In fact, that kind of rolls us into the next thing. Brendan, why don't you talk about probate sales when you have full authority?
Yeah, so in probate, you either have full authority or limited authority, and full authority is what people have most of the time. The process, at least as far as you don't go in front of the court to sell a house. Whoever is appointed the personal representative has that authority to sell the house. And really no deposit is really required, but working with a realtor, especially, you're never going to accept an offer that doesn't have an earnest money deposit. But in probate sales with full authority, like I said, they're similar to regular real estate sales. Deposits really follow local customs. And in, say, the Bay Area of California, the San Francisco, Oakland Bay Area, 3% is a common earnest money deposit. Whereas in a lot of, say, the Valley, Sacramento down to Stanislaus County and lower throughout the Valley, 1% has been very much the norm for years. And I've seen a little bit of variations of that, people coming up with more deposits in order to make their offer look stronger, that kind of thing. A seller can accept a contract on any terms that they really want to when it comes to deposit. So, there's nothing. I've actually scoured the probate code, did a term search and everything. There's nothing in the probate code that says anything about a 10% deposit is required. Not that I found. If you find it, let me know. It's pretty manageable for a buyer to put down up to 3% because most of the time they're getting a loan, which I think it's right into this next thing. What happens to the earnest money deposit once it's put in?
Well, it's actually pretty simple. The earnest money deposit, it simply gets applied towards the overall sales price of the home when escrow closes. Now, if for some reason the escrow falls out, then usually the earnest money deposit is returned to the buyer. It's pretty simple as to what happens to it. I think with the one topic before where you were talking about full authority, we should probably talk a little bit about limited authority.
Yeah.
Once you get into a limited authority probate sale.
And you mentioned it where maybe this rule came from, and you would know better than me because you've been doing probate for, you're in 4 days. Yeah, a little bit since you were like 2 years old, I think. Yep. So limited authority, when a sale's under limited authority, sometimes an attorney involved maybe will require a 10% deposit. It's not necessarily mandatory, but they may not, the realtor involved may not accept an offer unless there's a 10% deposit. And that's usually because of the time it takes to really get the whole process done.
Yeah, much more involved.
Much more involved, and there's a lot more, I suppose, legal costs or costs to the estate when you're going through that whole process. You have to schedule the court confirmation hearing, and there's publishings and all of that, and there's a lot of time that's put into that.
Absolutely.
So they want to make sure that a more significant deposit is put down. So that may be why you will see in a limited authority sale that a 10% deposit is required by the seller or realtor or whoever in that case, in that party. It's advisable often in those cases. The administrator or executor can decide on the deposit amount, really. It's just often guided by the attorney. Now, local rules may affect deposit requirements.
It can. Again, this is something, and I've talked about it in other videos about looking at courts' local rules is important because all courts have their own set of local rules in addition to the standard probate laws and rules. And it's possible that a court local rule may say they want a 10% deposit. And if the local rule does, you better do it.
Mm-hmm.
I will say this though, you and I have been involved in a number of limited authority court confirmation sales, and I've been involved in a number of them in my career. I have never seen a judge turn down a sale because someone didn't come in with a 10% deposit. And I'm not saying that a judge couldn't turn it down. Sure, they could, but you got to think about this. If you've got a sale lined up, everybody's ready to close, you're in court, nobody's objecting to anything, and they only came in with a 3 or 4% deposit, I don't think the judge it just wouldn't be right for him to say no. So, like I said, 10%, as Brendan was saying earlier, might be required by the attorney or by the realtor, or for some unknown reason, everybody thinks they've got to do that. I have never seen a court turn down a sale that's ready to go and everybody's happy when the deposit is less than 10%. I just haven't seen it happen. But still check those local rules, because if it does say 10%, you sure want to try to do that. So Brendan, that kind of rolls into the next little topic of buyer considerations that might be
Right.
important.
So when you're listing a property, if the attorney is, if you're an agent listing a property, or maybe the personal representative and the attorney is saying 10% or requiring some percent maybe higher than 3, ask them why. Because you're likely going to limit the pool of buyers. A 10% deposit can be difficult for many, many buyers, especially those with FHA loans, VA. Those FHA loans are a 3.5% down payment minimum. And then there's first-time home buyer assistance with FHA and conventional loans, where maybe they're only putting 1% down, or VA can be 0% down. And you might think, oh, well, those people should be buying homes. Well, that's going to be the majority of buyers. So you're going to limit the buyer pool by requiring a huge deposit that they don't have the money for. Now, you might think like, well, if there's a bigger deposit, then that they have more skin in the game. But just think about somebody who has an FHA loan putting 3.5% down. They're probably fairly limited on funds as it is. So a 1% deposit is a big deal to them. Maybe an all cash buyer, a 10% deposit. I mean, that's still a big deal, but it may not be personally a big deal to that person's finances as 1% of the FHA buyer.
Absolutely.
So yeah, requiring a 10% deposit will greatly limit buyers, and it'll probably get you a lower sales price. So I just find that to be not a great strategy. And now maybe let's go over a little summary of the deposit and how that works in probate sales.
Absolutely. What we've kind of talked about is that, the earnest money deposit will typically in a probate sale range anywhere from 1 to 10%, depending on the situation and the local rules and local customs. In a full authority sale, it's pretty much always going to be somewhere between 1 and 3%, which is fine. In a limited authority sale, depending on the situation, you might get stuck at that 10% maybe, but oftentimes it's less. And like I said before, I've never seen a situation in a court where they turned down a ready to go sale because the deposit was less.
On that, there was one that we did, it's been a few years now, and it was a limited authority situation. And the best offer we had, the highest best offer we had, was from an FHA buyer. They had a 1% deposit. It took, a few months to get to the court confirmation hearing, and guess what happened? Sale confirmed. No big deal. It never came up.
Yeah, the issue of the deposit never came up.
Yeah, and if it did, well, the whole point of the court confirmation hearing is so the court assures that the estate got the most proceeds for the sale. Right. So why would you limit that by raising the deposit? Yeah. And I think that goes into our final tip.
Sure. Yeah.
If you're a buyer or a buyer's agent, or even a listing agent and the attorney's saying 10%, if you're a buyer's agent, and you're seeing that they're requiring a 10% deposit, ask them why. They may not understand the probate code. A lot of times attorneys themselves, they don't really understand real estate. And that's no disrespect to attorneys.
No. But that's not their normal job in a probate. It's just not.
Yeah, where they're working through a process, which is what I think really probate is a process. Real estate has a process too, but you're doing things where you're thinking of how different situations and requiring a deposit, for example, are going to affect what the overall goal is.
Absolutely.
And our job as a realtor is to, in most cases, get the most for the estate in a probate.
I think you bring up a good point that in a probate sale, you've got these two different tracks running parallel to each other. You've got the probate process and the real estate sale process. And it's really important that it's coordinated so that they work together and end up with the same end goal, which is to get the probate home sold at the highest, best possible price.
Yeah, I like that a lot. So, I mean, in summary, it's 1 to 10%. But if you're listing a property I would just go by your local customs and go from there. Do what you can to get the most for the estate. Now, you may want to just know a little bit more about probate in a very short video. We have a video called California Probate Real Estate Sales Explained in 5 minutes. We're going to have that link next. It's actually less than a 5-minute video. It'll be right here.